George Washington and John Marshall were keen on replacing the Articles of Confederation because they failed to create an effective system to provide for the common defense. After the Revolutionary War, the states were refusing to pay their war debts. But under the Articles, the government couldn't directly levy taxes. It had to ask the states for money, and often they were refusing to pay. As a result, there were crackdowns on debtors, and the debtors were so angry that they would rise up in angry mobs, like Shays' Rebellion, which inflamed people like Washington and Marshall with fears of mob rule. Also, the states were discriminating against each other in matters of commerce and not allowing their goods to travel freely. So Marshall and Washington were determined to create a system, a union, energetic enough to raise funds for the common defense and provide for shared economic purposes, but limited and restrained enough to protect liberty. The Articles of Confederation had no executive or judicial or common legislative functions with the power to tax and to defend, and also the Articles required unanimity for every decision. So since all 13 colonies had to agree on everything, they were unable to agree and were unable to achieve these common purposes. The ratification of the Constitution was controversial because it was arguably illegal according to the rules of the Articles of Confederation. The Constitutional Convention had convened to replace the Articles, but the Articles required unanimous consent for any change. The Constitution came up with a different rule. It said in Article 7 that 9 out of the 13 states were sufficient for ratification. And by creating a ratification rule that diverged from the pre-existing legal instrument, some feared the Constitution would be viewed as illegal, others saw it as an exercise of the people's unalienable and natural right to alter and abolish government, and they insisted that the Constitution was legitimate. The ratification of the Constitution was controversial in Virginia, and the ratification debates in Virginia are a wonderful microcosm of the competing arguments for and against the Constitution. Leading the charge for ratification is James Madison, who's returned to make the case for an energetic but constrained government. The opponents are led by people like Patrick Henry, who object that the Constitution has created a consolidated government and insist that the preamble should have read, "We the states," rather than "We the people of the United States." Henry is supported by anti-federalists like George Mason, who had originally supported the ratification of the Constitution but came to oppose it because it contained no Bill of Rights. And Mason's Virginia Declaration of Rights became the basis for the Bill of Rights that Madison would propose when he changed his mind about the need for a Bill of Rights based on Mason's argument. And then finally, there were people like Edmund Randolph, who had started off by opposing ratification, one of the 3 men who refused to sign because it contained no Bill of Rights, but came to support it because once Virginia was the 9th state needed for ratification, he said its union or no union were in or out, and therefore he decided better in than out. The status of the Supreme Court when Marshall joined in 1801 was unloved, disrespected, and often ignored. And we can tell this by the fact that the first 3 Chief Justices had their minds on other things. John Jay, the first chief, left the court in 1795 to run for governor of New York. The second chief, John Rutledge, also left the bench to become a state Supreme Court justice in South Carolina. And the third chief, Oliver Ellsworth, at the same time was serving as an envoy to France. Basically, people turned down the job because it wasn't prestigious or powerful enough. And it was that court, whose powers were questioned and whose status was embattled, that Marshall joined and transformed into a fully strong and co-equal branch of the federal government. The Chief Justice could never have been compared to the President or Speaker of the House, as evidenced by the fact that John Rutledge would rather be a state Supreme Court judge in South Carolina than Chief Justice of the United States. That John Jay would rather be governor of New York than Chief Justice of the United States. Because the federal judiciary wasn't seen as a fully co-equal branch of government, it was viewed as the least dangerous branch, as Hamilton famously said in Federalist 78. The chiefs reluctantly served. They complained of their circuit duties, which exhausted them as they rode across the country from pillar to post, basically serving as the equivalent of trial judges in court after court. And that's why it was a job that no one wanted. The Anti-Federalists, led by Patrick Henry and George Mason, thought of the Constitution as a compact between the states. They thought so because that's the conception of the power of the states when they convened to create the Constitution. Under the Articles of Confederation, all of the states were sovereign, and the Anti-Federalists believed that they maintained that sovereignty. Federalists, led not only by James Madison, but most importantly by James Wilson, who wrote the preamble to the Constitution, disagreed. They insisted that we, the people of the United States as a whole, have the sovereign power. Wilson's original draft of the preamble read, "We, the people of the states of New Hampshire, Rhode Island, and Providence Plantation," and so forth. The next draft said, "We, the people of the United States," in order to signal Wilson's belief that the whole people were sovereign. Lincoln invoked Wilson's speeches at the convention when he denied the power of the South to secede during the Civil War. Lincoln said, "Since we, the people of the entire United States, made the Union, we, the people of the United States as a whole, would have to agree before it could be changed." The secessionists, led by Calhoun, disagreed, channeling the Anti-Federalist Patrick Henry, insisting that because each state was sovereign, it could decide on its own whether to leave the Union. And ultimately, that question of who is sovereign, the people of the states or the people of the United States, is settled on the battlefield of Antietam. It takes the Civil War itself, the bloodiest in American history, to settle the question of sovereignty in favor of we, the people of the United States as a whole, rather than we, the people of the states.
Didn't Thomas Jefferson sometimes speak as if he believed the Constitution was a compact between states?
Yes, Jefferson sometimes embraced the theory of the Constitution as a compact among the states, and in fact, at the end of his life, the great author of the Declaration of Independence was endorsing theories of state sovereignty that supported secession. It was a poignant ending for the great revolutionary who inspired the Constitution with his immortal declaration. And even Madison himself, the father of the Constitution, spoke of a kind of dual sovereignty. In Federalist 39, he said that the Constitution was neither wholly national nor wholly federal, but federal in some respects and national in others. The Bank of the United States prompted the first major debate in America about the scope of Congress's power to regulate the national economy. Opponents of the Bank of the United States insisted that Congress had no enumerated power to charter banks, and they also had a suspicion of monopolies of any kind. Supporters of the bank, whose arguments were ultimately embraced by Chief Justice Marshall, said that the necessary and proper clause of the Constitution, which they called the sweeping clause, allowed Congress to exercise not only its explicitly enumerated power, but any power that was necessary and proper to carry out enumerated powers, and the power to regulate commerce was broad enough to cover the chartering of the bank. That it was Hamilton who was leading the charge for the broad constructionists, Jackson leading the charge for the strict constructionists, and ultimately Marshall settled the question in favor of Hamilton rather than Jackson. People in the 1820s were keen to structure the Supreme Court because some of them felt that the court was usurping too much power. They objected to broad decisions of the Marshall Court that construed congressional power generously, including that upholding the Bank of the United States and encroaching on state sovereignty. And there was also a lot of discord after the financial panic of 1828, when national politics were thrown into chaos. And for this reason, populists, led by Andrew Jackson, endorsed a series of court curbing measures, from proposals to allow the people directly to elect Supreme Court justices, to proposals to restructure the nature of the court, and to allow the Senate to check the court. And broadly, they questioned the idea of the court as a co-equal branch of national government. At the same time that Jefferson was endorsing theories of state sovereignty that led to secession, he was railing against the Supreme Court, led by his detested distant cousin, Chief Justice Marshall. Jefferson had the most wonderful epithets for Marshall. He said of Marshall that he was guilty of twistifications. He said, if he asked me a question, the time of day, I'll say, "I don't know, sir, I can't tell," because any answer will be twisted against you. And Jefferson also attacked the judiciary as a group of miners and sappers led by the perfidious Marshall, whom Jefferson trusted not a whit. So part of the rivalry was personal, but it was also very much constitutional and structural, and Jefferson thought that the court under Marshall was usurping the people's will and it should be curbed. The Constitution does not mention the word slavery. And when James Madison's notes were published in the 1840s, the nation learned that Madison insisted that the Constitution deliberately did not introduce into its text the idea that there could be property in men. At the same time, there were a series of fatally significant compromises over the slave trade that infected the original Constitution. Some states wanted to ban the importation of slaves, others wanted to preserve the slave trade. The compromise was to allow Congress to ban the importation of slaves, but only after 1808. Most infamously, there was the 3/5 clause that allowed states to count their apportionment in Congress for all free persons, including those held to a term of service, but only 3/5 of all other persons, meaning slaves, so that the South reaped some but not all of the bounty of its infamous trade in slavery, with a corresponding increase in apportionment, although not a total one. And then there was the Fugitive Slave Clause that allowed Congress to compel the return of slaves who had fled their bondage. For all these reasons, opponents of slavery felt that the Constitution had made a compromise with sin. Supporters insisted that it was up to each state to decide whether to preserve slavery or not. And of course, it took the Civil War to answer the question. The framers made the compromises they did with slavery because they realized that no constitution could be ratified without them. Madison deliberately refused to take a position on whether or not there should be property in men, because he thought each state had to decide that for itself, or else the Constitution couldn't be ratified. So it was, for better or for worse, and some will say much for worse, pure pragmatic politics that allowed this compromise to take place. John Marshall changed the status of the Supreme Court by asserting its co-equal power to interpret the Constitution, and by asserting its unique power to strike down unconstitutional laws. The power of judicial review, in other words, the power to strike down a law that's inconsistent with the Constitution, had existed under English common law. It seems to be implicit in the Federalist Papers. Alexander Hamilton in Federalist 78 said that whenever there's a conflict between the will of the people represented by the Constitution and the will of their delegates represented by an ordinary law, courts should prefer the will of the master to the servant, the principal to the agent. So he seems to be saying that by striking down unconstitutional laws, the court is preserving the supremacy of the Constitution. But it was, of course, Marshall in Marbury versus Madison who first on the Supreme Court articulated clearly and unequivocally that power of judicial review. He did so in a remarkably subtle and wily way that still makes the head spin with admiration for his act of judicial jujitsu. And it made him both the greatest statesman of his age and also one who, while bowing to a battle that he knew he couldn't win in the short term, ended up shoring up the power of the court in the long term. Before Marshall, the court was very much not only the least dangerous branch, but the least respected branch. By the end of his tenure, the court was viewed at least as the co-equal of Congress and the president, certainly not their superior. Marshall asserted at the very least that each of the three branches had the power to interpret the Constitution, and that a law should not go into effect unless all three branches agreed about its constitutionality. He asserted not judicial supremacy, but judicial equality, a concurrent authority of constitutional interpretation. And he was successful enough that by the mid-19th century, his successor, Chief Justice Taney, who continued to broadly assert the power of the court in the tradition of his great predecessor, was able to strike down the first federal law as unconstitutional since Marbury versus Madison. The Dred Scott decision in 1857 struck down the Missouri Compromise one of the most infamous decisions in the court's history, but Tawney had the authority and confidence to do that and to challenge the Congress because of what Marshall had established before him. John Marshall was extraordinarily deferential to federal authority, and he rarely struck down federal laws, and the only one that he questioned was one that would have expanded the jurisdiction of the court itself in Marbury versus Madison, and it seemed that his willingness to strike down federal laws was limited to those that encroached on the authority and autonomy of the judiciary itself. It seems likely, therefore, that Marshall would have viewed the Missouri Compromise as one that had been endorsed by both parties, whose constitutionality had been repeatedly reaffirmed even by its former opponents. And when the Dred Scott decision was decided by itself, neither of the major congressional parties were clamoring for the elimination of the compromise. It was only a minority of the Democratic Party, led by Tawney, who'd questioned the constitutionality of the compromise when he was President Jackson's Attorney General, who questioned it. For all these reasons, Marshall, the great proponent of broad congressional authority and of judicial deference to Congress, I think, would have upheld the Missouri Compromise. It also seems likely that Marshall never would have reached out to decide the constitutionality of the Missouri Compromise. He famously said, "I'm not fond of butting my head up against a wall," as if in sport, and for that reason, he did not reach out to decide constitutional questions that he wasn't required to. And using his twistifications and careful strategizing, he might well have decided either in favor or against Dred Scott's claim to have achieved freedom when his master took him to Fort Snelling without deciding the broader constitutional question. In this regard, Marshall was a great constitutional minimalist, and the fatal flaw of his successor, Chief Justice Tawney, was failing to learn from his strategic vision. We all know the most famous statement by John Marshall about the Constitution. We must never forget that it's a constitution we are expounding. What does that mean? It seems to suggest that a constitution is not a statute, a lawyer's document, a technical series of rules that have to be applied in the strictest and least forgiving way. Marshall favored not living constitutionalism, but broad constitutionalism. He believed that the Constitution had to be interpreted so that it could adapt to the needs of the current time. And that was why he said that the necessary and proper clause should be interpreted broadly enough to recognize current economic realities. He didn't believe in bending the Constitution or inventing new rights, but in interpreting it flexibly. That's why some of the great acolytes of Marshall on the court, including Chief Justice William Howard Taft, have insisted that they, like Marshall, were not originalists. Taft explicitly rejected originalism and said we should not interpret the Constitution only in light of the original understanding of its framers, but in light of current realities. At the same time, Taft and Marshall were not living constitutionalists in the modern sense. They didn't believe that the Constitution could be bent and broken and stretched to any current exigency, or that its fundamental meaning should be transformed. They wanted to translate the text and history of the Constitution in light of its broad original purposes. So in that sense, you could say that they were originalists, and they did believe that the original purpose, broadly defined, should bind and be applied to current circumstances. It's striking that the debate in Marshall's day was not between originalism and living constitutionalism, but between strict and broad constructionism. And on that score, we can say that Marshall was a broad, not a strict constructionist. He did not believe in construing the document so strictly that the states were sovereign and the federal government was paralyzed and couldn't charter a bank. Instead, he believed in broad construction of federal powers. It's so striking to think of these men who came to Philadelphia to debate the Constitution and of the personal dynamics among them. It's impossible not to think of them in their boarding houses after the debates, drinking together at Franklin's invitation, debating, people who disagreed strongly during the day about fundamental questions like the nature of federal versus state power or slavery and freedom coming together to dine, sleep in the same boarding houses, and break bread. It's striking too about what a small group it was, 55 at some time, but really led by a few distinct individuals, many of whom had known each other and grown up with each other. The whole Constitution might be seen as a debate between James Madison and George Mason, both from Virginia, initially on the same side, determined to create a more energetic federal government, but coming to divide over the fundamental question of the lack of a Bill of Rights, so much so that Mason ultimately refused to sign the Constitution, along with Edmund Randolph of Virginia and Elbridge Gerry of Massachusetts, which is why in Signers Hall at the National Constitution Center, we have Gerry, Randolph, and Mason off in the back of the room because of their refusal to sign. Near Madison in Signers Hall is the rap star of the moment, Alexander Hamilton, proud and strong and spry and yet someone who didn't play a huge role at the convention. He was sort of in and out, and given the vagaries of New York politics, couldn't turn his full attention to the debate. His major role was after the Constitution and writing the Federalist Papers. In the front of the room in Signers Hall is George Washington, strong and tall. And it's impossible to understate the significance of his moral and physical authority. Were it not for Washington's shining reputation, the fact that all the delegates from North and South acknowledged his greatness and his neutrality, the convention would never have been successfully summoned and the Constitution would never have been ratified. The entire Constitution, if we had to choose a single man, can be attributed to the authority and power of the example of Washington. And then it's impossible not to be struck by the variety and color of the figures within the individual delegations. The Pennsylvania delegation is right up front at the National Constitution Center. And what a collection of geniuses and statesmen and rogues as well it was. There's Benjamin Franklin in the front, sitting. He said very little during the convention, except to make his famous remark about how the sun on Washington's chair seemed to be rising rather than setting at the end. But so much authority and so much respect, and his presence was crucial. Then there's Gouverneur Morris, tall with a peg leg. I mentioned rogues because he was said to have achieved the leg in an accident in a carriage after an assignation. But he was a great writer, the head of the Committee of Style, who wrote the final words of the preamble and crafted their immortal poetry. And then there was the philosopher of the entire convention, James Wilson, underappreciated today, but in some ways the most important inventor of the idea of national sovereignty. Without Wilson's genius, we wouldn't have declared that we, the people of the United States as a whole, were sovereign, as opposed to the king and parliament, as in Britain, or the individual states, as under the Articles. And then you think of the personal stories. Wilson went on to become a justice of the Supreme Court, but then died in debt, fleeing his creditors. The vagaries of fate and human experience are all represented by these great men. Roger Sherman, squat, powerful, a cobbler from Connecticut, as the musical 1776 put it, but the great compromiser who came up with a Connecticut compromise that merged the interest of the large and small states in the apportionment of the House by population and the Senate by individual states. In the front of the room is Jacob Broome, who was inviting people to sign because he was the last framer to sign. It's striking how young the framers were, many in their 30s and 40s. It's very sobering to think of all that these great men accomplished at a very young age. But it's such a collection of genius that it's impossible not to think that there was divine providence at stake. And that's why Madison always resisted calls for a second convention, because he said it was fate, it was luck, it was divine inspiration that allowed the Constitution to be drafted the first time, and it was too risky to call a second convention where the same hand of Providence might not smile upon the delegates. Marshall certainly knew that many of the delegates in Philadelphia, most notably Washington. And of course, it was serving under Washington at Valley Forge that led Marshall to say that he'd come in that service to see Congress as his government and the United States as his country, as opposed to Virginia as his country. People would refer to states as their countries, but serving in the Union Army made Marshall see the United States as his country, and it was Washington's shining example that helped solidify that national allegiance. It created in Marshall a lifelong suspicion of his distant cousin Jefferson, who did not serve at Valley Forge or in the Revolution, and who Marshall considered a shirker as well as the great Lama of the mountain. That was Marshall's insult for Jefferson, and it's not clear what it meant, but it doesn't sound very nice. And Marshall knew Madison, of course, with whom he'd served in Virginia politics, and Mason. And these are practical men of affairs. They're not philosopher kings. They'd served in politics together. And that's what made it so dramatic, that when the Constitution bore fruit and the government was established and conflicts between the president and Congress and the courts and Congress began to be established, Marshall was ruling on the judgments of men he knew intimately. Marbury versus Madison involves Jefferson, who Marshall knew all too well, and Madison, whom he knew as well, and President Adams, who'd appointed him to the Supreme Court and who wasn't at the convention but was there in spirit. So this is a group of men who served with each other in their youth, who came to maturity together at the time of the convention, and together worked out the meaning of the Constitution in the subsequent decades. The framers anticipated that the Supreme Court would be the head of the least dangerous branch. That's what Hamilton said in Federalist 78. Having neither purse nor sword, the court could not menace the country by arms or by money. At the same time, the framers did anticipate that the court would have a power to strike down unconstitutional laws, the same power to resist a law they believed to be unconstitutional that the president and Congress did. So in respect to judgments about constitutionality, the framers, although not all were united, Hamilton seemed to anticipate a co-equal power of constitutional interpretation in the courts, but he was confident that this would rarely be exercised, that fear of popular disapproval would dissuade the delegates of the people from passing laws that encroached on the Constitution, because Hamilton and the other framers were confident that the people would be the best defenders of liberty and would rise up against usurpations on their liberties before they could be enshrined into law. I think it's fair to say that the framers did not anticipate judicial supremacy. They never anticipated that the courts alone would decide all constitutional questions, or that every political question would become a judicial question. As Tocqueville said by the 19th century, that it was not anticipated when the framers wrote the Constitution at the end of the 18th century. So the courts have become far more vigorous in their assertion of the powers of judicial review than the framers anticipated, just as the presidency has become far more imperial than the framers anticipated, and Congress and federal power have expanded in ways that the framers never anticipated. If we ask what would James Madison make of the presidency, courts, Congress today, it's fair to say they look little like his original conception, because all have expanded their powers. Madison thought that it would be Congress that would act like an impetuous vortex, sucking new powers into its voracious maw, and each of the three branches has accreted power in ways that the framers feared, and the balance that's resulted is one that they would not have recognized. What would Marshall think of our courts, Congress, and presidency today? Each is far more powerful than he anticipated. A court that routinely exercises its power to strike down unconstitutional laws, not only passed by the states, but also by Congress, as well as routinely striking down executive orders of the president, is one that Marshall didn't anticipate when he recognized a power of judicial review mostly to ensure that the judiciary would be able to maintain its prerogatives against the usurpations of the other branches. An imperial presidency ruling by executive order is one that Marshall didn't anticipate because that's not the way Washington ruled. It wasn't until the Progressive Era that presidents like Theodore Roosevelt and Woodrow Wilson began to rule by executive fiat with increasing confidence. And of course, the administrative state is one that Marshall would not have recognized either. It is a fascinating question about what Marshall would have made of the Federal Trade Commission, because generally he was very deferential of congressional power of regulation and believed that Congress should have broad power to regulate the national economy. On the other hand, he didn't confront questions of delegation of congressional authority to the executive in ways that are raising current controversies. So although Marshall was no strict constructionist and would not have objected to the entire apparatus of the modern federal government as an unconstitutional usurpation, as some strict constructionists do today, it's fair to say that he would have been surprised by the growth of all three branches and how precisely he would have attempted to correct the balance, and whether he thought the courts had a central role in that is an important and question that's hard to answer.